Chapter 8. Alternative Dispute Resolution. Alternative Dispute Resolution, or ADR, refers to methods of resolving disputes outside the formal court litigation process. ADR is designed to provide faster, more flexible, and more efficient solutions to business conflicts. As commercial transactions and cross-border contractual relationships become increasingly complex, business actors often prefer ADR mechanisms to avoid lengthy court proceedings, high litigation costs, and the potential damage to ongoing business relationships. Business law literature emphasizes that ADR plays a crucial role in maintaining legal certainty while preserving professional relationships between disputing parties. In many modern legal systems, ADR is actively encouraged by governments and international institutions because it reduces the burden on judicial systems and promotes cooperative conflict resolution. As a result, ADR has become an integral component of contemporary commercial law and international business practice. ADR is particularly important in global business environments where disputes may involve parties from different legal systems. Traditional court litigation may create jurisdictional complications, while ADR mechanisms offer more neutral and internationally recognized solutions. For this reason, multinational corporations and international trade agreements frequently incorporate ADR provisions as part of their contractual frameworks. Methods of ADR. ADR includes several mechanisms designed to resolve disputes in ways that prioritize efficiency, cooperation, and flexibility. The most commonly used ADR methods in business disputes are mediation, arbitration, negotiation, and conciliation. Mediation. One of the primary ADR methods is mediation. Mediation is a dispute resolution process involving a neutral third party, known as a mediator, who assists the parties in reaching a voluntary agreement. The mediator does not have the authority to impose a decision. Instead, the mediator facilitates communication, identifies shared interests, and encourages compromise. In business contexts, mediation is widely used because it is confidential, flexible, oriented toward a win-win solution. Business law journals emphasize that the success of mediation largely depends on the good faith of the parties and their willingness to negotiate constructively. Because mediation focuses on collaborative problem solving, it often helps preserve long-term business relationships that might otherwise be damaged through adversarial litigation. Additionally, mediation allows parties to craft creative solutions that may not be available through formal legal judgments. Arbitration. Arbitration is the most commonly used ADR method in business disputes, especially in international transactions. Arbitration involves one or more arbitrators who act as independent decision-makers. Unlike mediation, the arbitral award is final and legally binding on the parties. In most cases, arbitral awards are enforceable through internationally recognized legal mechanisms. The advantages of arbitration include procedural flexibility, the ability to select arbitrators with specific expertise, confidentiality of proceedings. Many modern business contracts include an arbitration clause as a preventive measure to address potential future disputes. Arbitration is particularly favored in international commerce because it avoids the uncertainty of national courts and allows parties to choose neutral venues and applicable procedural rules. Other ADR methods. Other ADR methods commonly used in business practice include negotiation, conciliation. Negotiation is the simplest form of dispute resolution where parties attempt to reach an agreement without the involvement of a third party. Because it is informal and direct, negotiation often serves as the first step before other ADR methods are considered. Conciliation is similar to mediation. However, the conciliator may take a more active role by proposing possible solutions to resolve the dispute. This method is often used in commercial and labor disputes, where the parties require guidance in reaching a mutually acceptable outcome. Overall, these methods offer more adaptive and less formal alternatives compared to traditional litigation. Their flexibility allows disputing parties to tailor the resolution process to the specific needs of the dispute. ADR from a business law perspective. From a business law perspective, the use of ADR reflects the principle of freedom of contract, allowing parties to determine their preferred dispute resolution forum and mechanism. ADR also promotes economic efficiency by reducing the burden on court systems and accelerating conflict resolution. Faster dispute resolution enables businesses to minimize operational disruptions and maintain stable commercial relationships. However, the effectiveness of ADR depends on clear dispute resolution clauses in the contract, compliance with agreed procedures, the parties' commitment to respecting the outcome. When these elements are properly implemented, ADR becomes a powerful legal tool for managing business conflicts while preserving cooperation, efficiency, and long-term commercial stability.
Okay, see you on the top.
Yes.